When we interpret the Second Amendment right to keep and bear arms, we apply the text of the Constitution and then the history. What's very interesting today is that liberal Supreme Court Justice Ketanji Brown Jackson did exactly that in the context of another federal law. What can we learn? Stay tuned. I'll tell you all about it. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and learn about your rights. Okay, folks, so this is interesting. Today we had the first Supreme Court opinion ever authored by the new Supreme Court Justice, Ketanji Brown Jackson. This decision, as is the tradition, was a unanimous decision for all intents and purposes, authored again by Justice Brown Jackson. The reason why I'm talking about this in the context of the Second Amendment is, although this case did not deal with the Second Amendment, obviously, this case dealt with a technical federal law called the Federal Disposition Act and what happens when checks issued by companies like MoneyGram are not cashed. Who gets to keep the money among the various states? Was it the state where MoneyGram is located or the states where the checks were sent? That's not what's interesting, though. What's interesting is making a decision and interpreting the relevant law here. Justice Brown Jackson, who I think we can agree is probably viewed as a progressive since she was nominated by Joe Biden and has all the credentials and all the evidence of being a typical left-wing progressive on the Supreme Court in the ilk of Ruth Bader Ginsburg, for example, and Elena Kagan. That's my guess. We'll see what happens. But what's interesting is today she applied effectively the methodology of Nysurper versus Bruin and Second Amendment, including Heller. What I mean by that is, in her opinion, Justice Brown Jackson talked all about text and history involving the relevant federal law, which again was the Federal Disposition Act. And the reason why this is significant is I think this teaches us that when you are dealing with a Supreme Court issue, a legal issue, that doesn't touch fingers with a hot button topic like guns or abortion or gay rights or items like that, you will see that the left-wing justices on the court, the Elena Kagans of the world, the Justice Brown Jacksons of the world, the Sonia Sotomayor's of the world, are perfectly content to apply the text of the law as well as the history. To give you an example here, this is some of the language from today's opinion by Justice Brown Jackson. She talks about, quote, in the text of the statute, she references, then she goes on to say, because the plain text of the FDA applies, and then she talks about what's similar, sounds like an analog. We determine what similar entails in light of the FDA's text and context. So there you have the use of analogies. You also have the discussion of text and context. Sounds like text and history to me, all within today's decision. And here you have also in another part of the opinion, Justice Brown Jackson refers to, quote, the text and history of the FDA also suggest an alternative framing. Did you hear what I just said? So in today's opinion, a unanimous decision by the United States Supreme Court, authored by Justice Brown Jackson, the Joe Biden nominee to the Supreme Court, she's talking about, quote, the text and history of the Federal Disposition Act. Again, text and history. She goes on to talk about the statutory text or ordinary meaning of money orders. Again, text and history and text and history. And last but not least, she talks again, in any event given the history and text of the Federal Disposition Act. So again, here you have a unanimous decision where the justices have no problem applying the text of federal law and the history of federal law to reach a unanimous decision, which is really what should be happening in cases involving the Second Amendment. The text is clear and the history is clear, meaning that we had gun freedom going all the way back to even before our revolution against the British in the 18th century. And yet here, I'm betting you dollars to donuts that down the road, when we have our next Second Amendment case, you can count on Justice Brown Jackson and the other progressives, Justice Kagan and Justice Sotomayor, somehow ignoring the text and the history of the Second Amendment to rule against our fundamental rights to keep and bear arms. But I just want to show you and highlight this potential hypocrisy Where when it comes to laws that don't touch on cultural issues such as guns and the like, guess what happens? The progressives on the court have no problem applying the law the way it should be done, and they agree with the conservatives on the issue. But trust me, when you touch on the Second Amendment, on these other hot-button issues that should not be controversial as a matter of law, but do get controversial, trust me, the three progressive judges, including Justice Brown Jackson, will deviate from this opinion and the methodology that they apply today in this case called Delaware versus Pennsylvania and Wisconsin. Okay, folks, hope this wasn't too geeky for you. Again, touching on the Second Amendment indirectly, but it's important for you to know this to show the hypocrisy if these justices don't follow the text and the history of the Second Amendment in the way they did in today's decision. Okay, if you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.